Oh, I'm sorry, David and on behalf of the people, I apologize.
Thank you, Your Honor. Patrick Cherry on behalf of Mr. Young, who is present.
Thank you. You may be seated. Also here this morning is Ms. Odell. She is an agent from the Michigan Department of Corrections, covering today for Mr. Luke Blazak, who is a probation officer that prepared today's for Simpson's investigation report. Take a quick look here myself. I've got a few notes, but I don't think any more changes. Oh. CFJ 284, page 4. Ms. Odell, CFJ 284, page 4. I don't normally correct it, but I think I wanted to correct something. At the very top, the second word I think should be said, not sad. Very second word.
Sorry, what, Your Honor, which page are you on?
CFJ 284, page 4. At the top, there's just a misspelling.
Thank you.
It's not your fault. That would be all, Mr. Blazak. Just a moment. Okay. All right. I did not catch any other need for correction. Let's turn it over now to Mr. Denham. Mr. Denham, how about you? Any amendments, corrections, or objections to make to the contents of the report?
No, Your Honor.
Okay. Mr. Sherry?
Yes, Your Honor. Starting on CFJ 145, page 1,
Mhm.
under personal history, where employed, should be updated to reflect Lake City Forge.
Thank you. I did see that he was employed, and I noted that there back in the report on CFJ 28411. Well, actually, no, it said that he was employed, self-employed, but now he's got a job with Lake City.
Correct, Your
Oh,
Honor.
okay, all right.
That's why I just want to
Yeah,
update it so
yeah.
that everybody knows.
So we'll go ahead and make that a correction. That would appear on CFJ 145, page 1, and then obviously require a correction on CFJ 284, page 11. All right, thank you.
Following down that same page, alcohol end date should be 2018.
All right, we can go ahead and change that.
And then for opiates, the start and end date should be 2016 and reflect a one-time use.
Okay. Ms. Odell, any issues there?
No, Your Honor.
Mr. Denham?
No, Your Honor.
All right. That would also require a correction, Ms. Odell, back in CFJ 284, page 12.
Correct, Your Honor.
All right, thank you.
On CFJ 284, page 1, under the guideline scoring, the score is the same and for PRV 5, but I believe it's 3 prior scorable misdemeanors in adult history, not 4. So that scoring is for 3 or 4
Yeah.
misdemeanors,
All right.
and I believe it's 3.
Let's take a quick look. So we've got the first one appearing on condition 4 of 9. Oh, no, I think, no, the
That's a
other
low
one was,
severity.
no, there was one as a juvenile, wasn't there?
There were,
I see one.
2,
Go ahead.
sorry. I believe there were 2 as a juvenile and then 1 as an adult.
Correct. That is what I see. Okay, so John, so we're just changing the number. It doesn't impact the score. Thank you. Did you catch all
I
that?
got it, Your Honor. Yes.
Thank you. Mr. Cherry, anything further?
On CFJ 284, page 10.
Okay.
Down towards the bottom third, gang involvement.
Mhm.
The end date should reflect July of 2020.
I didn't know if there was mention of that somewhere else in the report, when it, I think probably up in the front, where it talked that he had been in the gang, but then had left it, so. Under,
Correct, Your Honor.
yep, thank you.
On CFJ 284, just a little bit more information about the new employment.
On page 11,
Correct.
okay.
Its start date was July 14th. He is a wheel abrader,
Oh, what?
a wheel abrader,
Okay,
and the pay is $17 an hour.
all right.
Which would change page 12 finances to an income of 2,720 per month.
All right, that's toward the bottom.
Correct.
So Dell, are you catching all that info? Thank you. Anything else, Mr. Chair?
Finally, on page 13, under assets,
Yeah,
the dirt bike has broken and been gotten rid of, so it's no longer an asset.
all right, we'll cross that out.
I'm sorry, last thing, the CFJ 101, page 1, on assets, then it should be no. And then under dependents, he has a baby on the way, but the baby has not yet been born. And so I'm raising that issue because I think it's probably should be 0 at this point, but the baby will be born in the next month or so.
Let's take a look here on CFJ 284. Moment. Maybe under, on page 11, underneath family narrative, we could put a statement underneath marriage narrative. Miss Odell?
Yes, Your Honor.
Yeah, underneath marriage. Oh, actually,
It
does
is
say-
there.
It does say expecting their son. I think that's fine. I'll
Okay.
just leave it as that. As long as there's something in there, we understand.
Understood. Then as to the scoring of the guideline range, after reviewing the file and talking to the prosecutor, I think we both agree that offense variable 3 should actually be scored at 0 points, which would change the total OB to 0, OB level 1, with a guideline range of 0 to 17.
Mr. Denham, your position on that?
So Your Honor, there may be somewhat of a disagreement between the probation department and myself. The extent of the, when at the scene, EMS did see him, there was apparent laceration, that there is no other information available to the people in terms of any type of treatment or injury other than that laceration that was immediately observed by EMS. Ms. Odell is taking the position that it is properly scored, but again, I will acknowledge that that is the extent of what occurred in this case in terms of any known treatment. So we would leave it at discretion of the court, Your Honor, the people.
All right.
To flesh that out a little bit, Your Honor, in the report, there is no description of the laceration. It just says laceration. The prosecution did reach out to the victim. The victim provided no additional information regarding the injuries.
We have a statement today.
We do not, Your Honor.
Thank you. Okay. ERR, sorry, OV number 3 is scored for physical injury to a victim. We know that there was no death, of course, caused. We know that there was no life-threatening or permanently incapacitating injury. So we're now down to whether or not it's 10 or a 5 or a 0. If 0 would say there's no physical injury to the victim. Well, that's not true. So I don't think it's 0. The question then becomes, is it 5 or 10? Well, when I look at some of the case law here, such as People versus Armstrong, 305 Mich. App 230, a 2014 Michigan Court of Appeals decision. It was discussing some of the language of MCL 777.33, parenthetical 1, parenthetical D. It states that OV3 must not be construed in a way that would allow the court to assume that all bodily injuries require medical treatment when there is no evidence that treatment is necessary. However, there was evidence that treatment was necessary, and that was discussed on CFJ 284, page 3. One moment. Says that the defendant had cuts below his right eye and on his left side of his head, the left hand side of his hand. It also said that on page 2 of that same section, that, quote, Wayne Nelson was requesting to be seen by EMS for a head laceration. When the deputy arrived, Wayne Nelson was receiving care from EMS, which states that the defendant did receive medical treatment. The court therefore finds by a preponderance of the evidence that offense variable 3 is appropriately scored. Next one.
I just want to clarify on page 3 at the bottom, when you were reading, those were the defendant's injuries, not the
Oh,
victims.
sorry. Thank you. Thank you. I did. And you're right. I see that now as you started to talk. I'm flipping through the pages, but still, I don't need to look any further than page 2.
Okay.
Underneath that first paragraph, underneath description of offense narrative. Again, he had a laceration and he was getting treatment from EMS. So by the preponderance of the evidence, I find that it's supported.
Thank you. No further corrections, additions, or deletions.
All right, thank you. Allocution, Mr. Cherry.
Thank you, Your Honor. May I approach?
You may.
I have a letter of support here. It's addressed to Judge Ransom, but I think it was intended for Your Honor.
Well, that's okay. Hopefully she doesn't mind me reading her mail. All right, one moment. All right, thank you. I've read that letter.
Thank you.
That is a letter that apparently must have been presented to Judge Ransom back in March of this year when the case first arose, maybe probably for consideration of setting an appropriate bond. But I still understand its application today. Thank you.
Thank you, Your Honor. In meeting with Mr. Young, I explained to him that likely today, Your Honor would go through his criminal history one by one, identifying his probation violations and the things that he had done in the past and how he had violated probation in the past. And so it's not going to be a surprise to him. What I'd like to emphasize for Your Honor is the young man sitting before you today is not the same young man that you're going to be reading about in his criminal history. There's in his lifetime, maybe not in mine, but in his lifetime, a significant gap of time that has occurred between his prior conduct and his conduct today. There is no alcohol involvement in this crime. There is no drug involvement in this crime. There is no gang involvement in this crime. All of things that Mr. Young struggled with in his earlier youth. And so I think that there's a big difference between the young man that you're sentencing today versus if he was still involved in those things led to the conduct that the court is sentencing today. This is a situation rather of poor impulse control, as the probation pointed out in their PSI, and not dealing with a terrible situation in a positive way. And so I want to linger on that a little bit because it doesn't excuse his actions, but it does give the court some context for the actions. Mr. Young's fiance was employed at BC Pizza as the manager, and throughout that time discovered that there were claims of sexual harassment, some that she experienced herself. She tried reaching out to corporate, and corporate would not entertain her calls and said, this is a franchise, so this is an owner issue, nothing for us to deal with. Frustrated, she quit her job, went home, told Mr. Young about what was going on, and rather than helping her to find a positive course of action, either through bringing suit or some other way of dealing with the situation, he took it upon himself to handle it in a confrontational way. That was the mistake. That was the conduct that we're sentencing here today. And so I think that it doesn't excuse it, but it does give context as to the source of frustration and how things began. He did try and engage the victim in a conversation that he wasn't happy with the outcome with, and so he turned it physical. That's the problem. And so I think that's conduct that we can actually rehabilitate in this young man. He's demonstrated that the system does actually work for him. He was in the system. The other thing I do want to point out is several of his convictions all resolved at the same time. And so there's rather than these 8 felonies and 3 misdemeanors that look sort of expansive, they were actually sort of isolated in time areas. So he worked through the system. He went to detention. He worked through the jail program, SAI boot camp. He's no longer using alcohol, no longer using drugs, no longer involved in gang activity. And for a period of about 5 years, had absolutely no issues with his conduct at all. And so this is one lingering issue that I think we can help through counseling, anger management, things like that, how to make good choices, good coping mechanisms when he gets frustrated. I know that the bottom of the guideline range is 5 months. I understand the recommendation of probation looking at the criminal history, but I don't think it fits what happened here. And, you know, obviously the court is aware that he's got a baby due in a month. He's got a good job where he's making money, and even in a local jail sentence, Missaukee County is no longer doing work release. So we're taking a working productive member of the community out of that working productive area. And I just don't see how that helps the defendant stay on the right track. I do understand the deterrence and punishment aspect. And so I understand there's probably got to be something, but I'd ask the court to keep it as minimum as possible so that we can keep Mr. Young on the right track while deterring other people from engaging in this kind of conduct. And so I'm asking the court to either sentence at the bottom of the guidelines or deviate below the guidelines in this situation.
Thank you, Mr. Chair. Mr. Denham.
I think it's real fortunate that the victim in this case, Mr. Wayne Nelson, didn't suffer more severe injuries. Certainly, it could have been worse given the factual scenario. So it's fortunate that there weren't significant injuries in this case. I don't know what the circumstances were surrounding it. Defendant has indicated through counsel that there were some outstanding issues with employment of a significant other. But irrespective of that, obviously, there are other remedies that can be taken, and it would never justify taking an assault. This is a situation where the defendant approached the victim in the back of his business, punched him several times, body slammed him, pinned him to the ground, and for a brief period, put his forearm across his neck. So it was a significant assault. It's fortunate that there weren't more serious injuries, and we believe that the recommendation is sound, Your Honor, and we would ask the court to follow the recommendation.
Thank you. All right. Mr. Young, if you choose to make a statement, you have the right to do so, and now would be the time. Is there anything you wish to say today, sir?
Yes, Your Honor. I'd just like to say I'm sorry for everything that I put everything through. I was been handled different, could have went a different way, and I've taken into consideration I have changed my life around. I am trying to do better. I have a son on the way. I trying to make a better life for myself and for him. I'd just like you, if you could, please take that into consideration.
All right. Thank you.
Thank you.
All right. Trying to figure out where, again, and I don't know if I can find the right or perfect place. That's correct. I'm going to go over the defendant's prior criminal history. I'm required to do so, or I believe I'm required to do so. And it is 25 years of age, and he's already accumulated quite a little criminal history that began when he was a juvenile. And that would have began back when he was about 14 years of age. He began by becoming a thief and stealing from people or from businesses. So he is shoplifting. Either that was planned, or, to use the phrase used by Mr. Cherry, impulse control. He made it placed upon probation. He had to be placed in detention because he went AWOL from his home placement. He was discharged from that probation, apparently unsuccessfully, in 2015. He made it less than a year. When he picked up the next case, which was another impulse control issue, which was theft, specifically unlawful use of a motor vehicle. So the detention home didn't work, the placement home didn't work, and he continued to have issues with impulse control. Looks like again he went AWOL from this placement, and he was then arrested for another retail fraud, and this one in Kalamazoo. And I'm going to say, by the way, disposition in entry 2 of 3 was on April 14th of 2016, and he made it 6 days before picking up another conviction involving impulse control, because it was back to thieving and stealing from shoplifting from businesses. In that case, he had other issues with going AWOL, leaving programs, and he failed, and he was discharged in 2017. By that time, he had become an adult. His first adult case came about in July of 21st, 2017. So right there, I know. Oh, by the way, and the next case was yet another larceny case. So far, within those first 3 years, bridging being a child, a juvenile, and adult. Probation didn't work, detention didn't work. And he still can't control his impulses of stealing from people or businesses. He was given boot camp, got another opportunity, and he failed that as he was unsuccessfully terminated. Now, at that time, he had back-to-back cases going on. That one last one I talked about came about on July 21st. Then he made it 4 days, still on juvenile probation, and yet picked up another charge. So he's got a couple of cases going on at one time. And begins the stretch that Mr. Cherry was talking about. He was given a sober living facility. Entry 3 of 9 occurred while on bond, so he couldn't comply with bond, he couldn't comply with detention, he couldn't comply with supervision. And what happened? Well, we got more theft type of crimes. So also we know that boot camp failed. And he was unsuccessfully terminated from probation in that file. On October 31st, 2017, he picks up his 4th adult case while on bond, and we're back to stealing cars. He got probation. He was discharged unsuccessfully. He picked up 5 of 9 while also on probation. While on bond, and without having to take much surprise, we look and see that the defendant was back to stealing. Number 6 of 9 occurred 6 days later, and also we dealt with more stealing of cars. He got probation. Probation was terminated unsuccessfully, and he got his first prison sentence. 7 of 9 occurred all about that same time, and of course, it's larceny cases and stealing.
Your Honor, I'd just clarify on number 7, that actually occurred back in 2017, but it was sentenced on the same day.
Yeah. Thank you. Number 8 of 9, the one just before this case, he had 6 cases all pending on or about the same time, or the events allegedly occurred all or about the same time while on bond. And sure enough, we're back to impulse control because he's stealing. Now, he does have about a 7-year gap from that case. However, we look back and see that he was really on parole for number 6 of 9 until July 24th of 2021. Now, I'm looking here to find out what this young person has learned. Well, unfortunately, not much. He still uses marijuana at the age of 25. We know that that is, well, now legal, but he used it for a long time while it was illegal. And it has, as we are being told more and more these days, have an impact on somebody whose brain is not fully developed. And if he's going to keep smoking weed, it sure as heck is not helping, because he is on a path of making stupid decision after stupid decision. Again, we're here today for his 8th felony conviction at the age of 25. So then I want to see, well, what has the defendant done in using his time effectively? Well, he went to jail. He never got his diploma. He's been off of parole for 4 years. He never went and got his GED.
Your Honor, he did get his GED through MDOC.
Oh, he did. There we go. I'm sorry. He did get his GED. Thank you very much. I'm very sorry that I missed that. I'm really glad. But what I also see here is for 4 years, I was tempted to ask him the question, but I didn't. What did he do for 4 years? Nobody filled in that gap of time. His entire time of being an adult after 2021 till 2025, it doesn't look like he did anything. Now, yes, he's got a job, but as a young man who's 25 years of age, his first job began 6 months ago. So,
If I may, Your Honor.
sure.
He'd like to add, those are the listed jobs that he put down. There were jobs before that if the court would like to inquire.
Now, what did you do?
I've worked mostly factory work.
Okay.
In Cadillac, I've worked at Hutchinson's and Port Warner. I worked at Hutchinson's when I very first got out of prison in 2020. That was my
Alright,
first
well,
job.
good.
Uh,
That's the kind of stuff. So here's just a lesson. What I'm looking for are, just like anybody who goes to apply for a job and an employer, a potential employer is looking at it, they want to know what are the gaps. And when I see gaps, you're all leaving me to fill in the blanks. So I'm glad to hear that you were doing, I'm first of all glad, I missed it. I forgot to circle the GED. I'm very glad that that was caught by Mr. Cherry, and I very much appreciate him interrupting and letting me know. I'm also very glad to hear that you had a job, because what I'm looking at here isn't positive. And if Mr. Cherry, and I'm not picking on you, I'm just saying, if we're gonna focus on something, let's focus on and give me the full detail. Right? Sure, you got a job, great. All I can see here is that you worked for 6 months, but now I have a better idea. So that's helping. Because you had a really rough stretch from 2014 until 2021, when you were finally off of parole, with more criminal convictions than 99% of every human being that lives in this country. So, but you got to stop smoking weed. You're on a bad, it's not helping you.
can I
So,
say something, Your Honor?
yeah,
I plan on stopping as soon as my son's born, so I don't want him to be around anything like that.
yeah.
I do
All right,
want
well,
to try to set the best example as I can, because I know I have went down the wrong path.
all right, well, that's great for your son, but here's one thing that's not good. You're still doing it. So far, impulse control and things like that, and substances into a 25-year-old brain who's been doing it since he was 14 is messing you up. I'd much rather use a different word than the word messing, but I'm going to stick with that one. It's messing you up. Yeah, sure, it's legal, but the same thing. Mr. Cherry talked about how you're not drinking alcohol. Well, great, but you're still doing weed, which means you're still messing with your brain. So, whatever. All right, so, and then this case here is all about impulse control. So, well, in one way, Mr. Cherry argues that you're learning some lessons. You haven't been in trouble for 4 years. Well, you shouldn't be in trouble at all. And impulse control is the problem. I don't really know much more than what I see in here about your life and what's led. I know there was a divorce, I think, in your family and things like that, but yeah, that's not a big deal. That happens to most people nowadays. It seems like at least more than half of the marriages. I don't know. But
If I may address that topic that the court just brought up.
sure,
In the convictions, it does outline during his first conviction, he was a ward in a neglect abuse case, followed by foster
Yeah.
care and
yeah,
some placements. And so,
yeah, and I understand that, and I could see obviously because I mentioned how you had problems in the home placements. When I say I don't know much, I don't know what the abuse and neglect was. And I don't know if I need to know it, because at this point in time, you're about to become a father. So all that other garbage doesn't matter anymore. It's no longer a justification. Once you have a child, your stupidity has got to go away. It's no longer a justification for the fact that you had a bad upbringing. Now it's the reason why you help your child have a better upbringing. Doesn't mean you're going to be perfect. You're still going to screw up, but let's make sure that it's not criminal screw ups. So, all right, here we go. The sentence of the court is as follows, and I find it to be reasonable, proportionate based upon the factors that I've discussed. And court places the defendant on a period of probation for 36 months. The court adopts the terms or conditions that are listed in the pre-sentence investigation report on CFJ 145, pages 2 and 3. I find that those are well suited for rehabilitative purposes. That includes any and all controlled substances, which still technically covers marijuana. And if you didn't think that, then you'll also see that it says no mind altering substances. So I can't stop you from using medical marijuana, but you can't use recreational marijuana while you're on probation. So this not waiting until your son's born, it stops today. All right. The court assesses a $68 state minimum fee, $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee. I assume we had DNA. Is that correct, Mr. Denon?
Yes, sir. Your Honor, I'm retained.
Oh, I thought it said appointed on there. I double check.
It may have, and I didn't catch it.
It says appointed on CFJ 145, page 1.
I'm retained.
Thank you. We'll go ahead and make that change. I'll strike the attorney fee. Thank you very much for letting me know. There's a supervision fee of $30 a month or $60 a month if there's any electronic monitoring. So that leaves just this question of any period of confinement. We're in an intermediate sanction cell. The court does not need to find reasonable grounds. However, the court still must discuss its reasonable proportionality based upon the defendant's prior criminal history, his repetitive violations of bond, violations of probation, violations of home placements, going AWOL, the issues that it continues to be a challenge of impulse control. The court finds that the defendant isn't learning his lessons as well as he should. You're going to need to find a way, and hopefully Miss Odell helps get you into some kind of anger management type of program so we can get you some understanding. So when you start to feel that switch flick, you can calm yourself down, go for a walk, maybe your wife, your girlfriend, fiance, whatever she becomes, ties you down, I don't know, locks you into a room. I'm sorry, that would be unlawful imprisonment. But hopefully she comes up with something that's effective to work. I still believe that a period of confinement is appropriate. You're looking at a straddle cell. There is absolutely no reason for me logically to not give you a prison sentence, but I'm not going to. Obviously, I already given you probation, so everybody here knows what's going on. I haven't heard anything today from the victim, so I want to make a note of that. Without hearing from the victim, I don't have much to swing me the other way. And I'm not criticizing the people, of course, with that, or even the victim. But I'm just saying, obviously, I don't have anything to swing the factor the other direction. The court sentences the defendant to a period of jail for, I'm going to say, one moment. While I respect and appreciate Ms. Odell's recommendation, sometimes I like just to differ so no one expects me to always adopt what the probation officer says. The court sentences the defendant to 210 days in the Missaukee County Jail, and the defendant receives the credit listed, which was 3 days. In that 200, I'm sorry, by the way, for probation, you have the right to be considered for early release from probation if you are satisfying all your terms or conditions at 18 months. The fines and costs are due within 59 days. 56 days. I knew I said that wrong. And if you don't pay them, then an assessment of 20% can be added to it. But as long as you're compliant with probation, you can work out a payment schedule with them, and I won't add the penalty. Now you're going to get obviously good conduct time credit, so that's going to be less than 200 days. It should be down to 180 days. All right. I hope that you take some time to think about things, write down some goals, maybe start journaling a little bit, things that you've learned in your life. Things that you thought you learned for about 3 or 4 years and realized because of this, holy cow, I didn't really learn them. Or maybe I addressed one set of issues, but not the next set of issues. And while I can't order you to, maybe write a letter to your son today or sometime over the next couple months, or continue to write him a couple letters. He's gonna know about your past. There's nothing wrong with him knowing about your past. Let him learn from you and how you deal with them and how you move forward. We all really hope that this is the last time you ever have to come into a courtroom for an involuntary reason. I guess that's the best way to say it. All right, thank you. Anything further, Ms. Odell?
Your Honor, the thing is, Mr. Cherry had mentioned there's no longer work release in jail. I don't know the jail rules, but I would not be opposed to work release.
If he
they offer it to
qualifies,
be qualified.
if he qualifies, I'll approve, I'll authorize it. All right, Mr. Cherry's gonna bring to you, Mr. Young, 2 copies of one document. You're gonna place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges receipt of the other copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. You understand?
Yes, sir.
All right. Today went better for you than I had my suggestions and ideas on. Not really, it's basically because I thank you, Mr. Cherry, for catching the GED portion and you filling in the gap about employment. That's
Yeah.
what kept you local. Yes, sir.
Would the court consider, with the baby due in September, a
we get-
furlough at the time of the
If-
birth?
If you get there at that time and the prosecutor agrees and stipulates, of course, I'll grant that.
Thank you.
Okay, all right, we'll do, generally what we'll do is we'll put them on tether for a couple of days or a day or two. I might say 2 days, because if we want to give you, well, anyways, you all figure it out. I'll authorize it. I think that's fair and appropriate, because what I'm really wanting here is just to help his child. That's what today's sentencing in my mind is all about. Well, helping him so he can help his child. Thank you very much. We're good.
Thank you, Your Honor.
Yep.
May I approach?
You may, thank you. Our next case here is People of the State